This is the First Amendment Salon of 2017. We are beginning our fourth year, and on behalf of my co-chairs, Ron Collins and David Scover, I welcome you all. We do these salons in cooperation with the Floyd Abrams Institute for Freedom of Expression at Yale Law School and with the Foundation for Individual Rights and Education. You can find the video of these salons posted on the FIRE website. Our next salon will be April 5th in New Haven, also at the lunch hour on the East Coast, and it will feature Floyd Abrams talking about his new book, which will be out in April, called The Soul of the First Amendment. I'd like to thank the salon's very good friends at Davis Wright Tremaine for making their offices available to us today. I'd particularly like to thank Rob Balin in New York and Laura Handman and Connie Pendleton in D.C., and most particularly Kelly Sager here in L.A. I first approached Kelly with the idea of doing this salon about 10 days ago, and she was able to put it all together between what I think were two appellate arguments, so I'm especially grateful to Kelly. For those of you who have not been to a salon before, let me just say a word about how they work. We have two principal discussants who are seated up here at the head of the table, and I'll introduce them in a minute. They will have a discussion amongst themselves after they finish eating their lunch. They will have a discussion amongst themselves for about 45 minutes, and then we will open it up to comments and questions from the audience. I say comments and questions because this is designed to be not a Q&A necessarily with the folks at the head of the room, but a discussion, and we expect and hope all of you will contribute thoughts and ideas and observations. With that, let me very briefly introduce our discussants. Jim Newton, who is over here, who will act as kind of an interlocutor and master of ceremonies today. Since 2015, Jim has been at UCLA, where he teaches in communication studies and public policy, and is the editor-in-chief of Blueprint, a magazine covering policy challenges here in California and Los Angeles specifically. Prior to that, Jim spent 25 years at the Los Angeles Times in various positions, reporter, columnist, bureau chief, and for the last several years of his tenure at the LA Times, editor of the editorial page. He is the author of three incredibly good books, most notably for today's purposes, Justice for All, Earl Warren, and the Nation He Made. Jim will be talking to and asking questions of Eugene Volokh, who is the Gary T. Schwartz Distinguished Professor of Law at UCLA Law School, where he teaches, among other things, free speech law, tort law, and religious freedom law. He runs the First Amendment Amicus Brief Clinic at UCLA, and many of you know him as the lead author and proprietor, I guess that's the right word, yes, of The Volokh Conspiracy, a blog that appears, among other places, in the Washington Post. For present purposes, it is interesting to note that Gene clerked on the Supreme Court for Justice Sandra Day O'Connor and did it the same year that Neil Gorsuch clerked on the court for Justices White and Kennedy. And the topic of today's discussion is Judge Neil Gorsuch and the First Amendment. So that is particularly a good insight that Eugene might have, among other things. With that, I will turn it over to Jim, and we'll get the discussion started.
Terrific. Thank you, Lee. Thank you all. It's nice to be with so many familiar faces. I'm mindful that our call in various rooms across the country here include a lot of people who are very fluent in these cases. No doubt many of you participated in some of these cases. Given that, my goal is to say as little as possible here today. Instead, my plan is to speak with Professor Volokh for about the first 40 or 45 minutes, and then turn to you for questions. But having said that, if issues occur to you as we go, if you have something to say, please do. Don't sit on your hands. It really is meant to be conversational. I'm much pleased for the introduction from Lee. So I will just add that it's a pleasure for me to be with all of you, and especially to meet Professor Volokh, whose office is about 100 yards from mine, and whose writing I've been reading for many years, but have never had the chance to meet until just a few minutes ago. So it's a pleasure to meet you. Likewise. So with that, questions. Let me ask you a couple just general questions before we really plunge into the First Amendment material, if we could. The first being a political question, really, which is, how much doubt, if any, do you have as to whether Gorsuch will, in fact, be confirmed? Is there any combination of Trump's sagging popularity or a leftover feeling about Merrick Garland that could make an unexpectedly difficult ride for him?
Well, given that I completely mispredicted everything that would happen in the election campaign,
I still think Marco Rubio could pull it out.
I have totally lost confidence in my ability to make political predictions. Even legal predictions are hard enough. So I don't know. I'm hoping that he'll be confirmed. I assume that he will be confirmed. My sense is that even Republicans who disagree with Trump on many things will find much to like in Gorsuch. My sense is at least a few Democrats will find Gorsuch to be probably the best bet for them, given the likely options. And I doubt that they're going to think that they can hold out for 4 more years on this. I think it's one thing to block until the next election, which is in November. I think that is both practically more doable. I mean, that's practically more doable because politically it's more sellable. I think it's harder to say, well, no, we're going to hold out for 4 years or even 2 years. But who knows? Who knows?
Fair enough. The second, and this is more by way of a caveat question than a political one, tell us a little, what we're going to be talking about here is cases and how he has ruled or concurred or dissented in various cases as an appellate judge.
Right.
How much should we be mindful in doing that about the limitations that it places on us in terms of understanding how he would actually behave as a Supreme Court justice?
Well, very much so, because for starters, there are times when he's bound by Supreme Court case law in a way that he won't be when he's at the court. Obviously, even justices who are very willing to reverse precedent, that's comparative by and large. Justices will follow precedent just because otherwise the system won't run. Lawyers won't know which arguments to make and which ones are foreclosed. But on important issues, the justices have more flexibility than judges do. I think that in some measure can be accounted for to some extent by looking at whether the judge seemed to apply a rule, the judge as a circuit judge or as a state Supreme Court justice seemed to apply a rule kind of grudgingly or because his hands were tied, and to what extent were there situations where his hands weren't tied and he seemed to apply the rule in a particular way because that's what his discretion allowed him. But obviously there's a limit to that. And on top of that also the job changes the man. Sometimes it changes him quite markedly, as was the case with Blackmun. But other times it just changes the kinds of issues. For him, changes the perspective. Mm-hmm. Working with his colleagues might influence him in various ways. We all are influenced by our colleagues in working in collegiate environments, and it's a different set of colleagues up there. So it's hard to tell for sure. I think what one usually looks to is kind of the political movement from which this person is drawn. Political is perhaps the wrong term, but kind of the ideological, the side of the aisle that he is on. One difficulty is it's hard to tell for sure with free speech issues because they don't line up, many of them at least don't line up neatly on conservative liberal sides. I do think it's a pretty fair bet that he's more likely to vote with the conservatives, let's say, on campaign finance related issues than with liberals or campaign speech related issues, just because, again, one can sort of assume that that's where the modern conservative liberal movements are. But on things like libel law, for instance, it's hard to tell for sure. So it's very difficult to predict. There are only kind of general guesses one can make, but one has to realize the limitations of this.
Mm-hmm. Very good. All right, so I sketched out a few areas to try to touch on today. You mentioned them. So some are campus speech, press, protest/grievance, political speech, campaign contributions, parody, and defamation. And so maybe just to walk those through a couple cases at a time, and I'll just set up for the take on. Whoever's making that noise should really stop it. All right, there's several things in the area of campus speech, and actually let me read you 2 fairly brief paragraphs. These are quotes not from opinions of Judge Gorsuch, but rather from writings from his days as a student at Columbia. First, he writes in 1986, the question here is not whether, quote, the Marines should be allowed to recruit on campus, unquote, but whether a university and its community, so devoted to the freedom of individuals to pursue their own chosen lifestyles and to speak freely, has the right or obligation to determine who may speak on campus or what may be said. To fulfill an immediate end, we are likely to forget the underlying principle that every human being, according to our nation's proclamations and reinforced by our university standards, has an inalienable right to express himself or herself, whether we agree or not. Free speech works. It works better than any form of censorship or suppression, and in exercising it vigorously, the truth is bound to emerge. That's a statement from 1986. I'll just read a shorter statement that the judge wrote, then still student, Gorsuch wrote in 1987, the following year, in which he said, last Saturday's march was more of a demand for the overthrow of American society than a forum for the peaceable and rational discussion of these people and events. Those who addressed the march argued not for change within the system, but for a radical change of the system. Doesn't go on to describe what he would do about that. But how do you read those two statements? These are very obviously young person statements. But in terms of what he thinks about campus speech.
Well, I don't know how many of us have the same views now as we did when we were 20 or maybe even less. I guess he's 49 now, so would have been
86.
Would have been 19 or 20. Very hard, I think, to evaluate a man of considerable years, I could say, being his age. Based on that. Again, I think that the general sense is that these days the conservative movement, especially I think the movement to which it seems to me that kind of conservative intellectuals like Gorsuch, I think he is very much an intellectual law, tends to be relatively pro-free speech and campus speech matters, relatively resistant to calls for kind of respect to administrative prerogatives within the campus and the theory of the government acting as manager. It wasn't always so. Rehnquist, for example, belonged to a different movement. But I would look more to where people kind of who I think are in Neil's natural intellectual point on the spectrum, what they have generally said. And they have generally been within that generation and that kind of ideology and generally been pro-campus free speech rights. But again, whether we're sure of that, one can't be sure of that. And I wouldn't rely much on what was written 30 years ago.
There's another case, more recent, although less related to student speech, although I must admit it has one of my favorite passages of his writing. This is a case that begins with a seventh grader who's taken out of class for faking burps and disrupting class. and the majority ruled against the student who was suspended, and Judge Gorsuch dissented. He wrote, if a seventh grader starts trading fake burps for laughs in gym class, what's a teacher to do? Order extra laps, detention, a trip to the principal's office? Maybe, but then again, maybe that's too old school. Maybe today you call a police officer. And maybe today the officer decides that instead of just escorting the now compliant 13-year-old to the principal's office, an arrest would be a better idea. So out come the handcuffs and off goes the child to juvenile detention. My colleagues suggest the law permits exactly this option, and they offer 94 pages explaining why they think that's so. Respectfully, I remain unpersuaded. As I said, one of my favorite pieces of writing.
Yeah. I think this is an important case. I think it's an important case because it shows Gorsuch as the kind of maybe stickler for a narrow and clear reading of criminal laws and criminal cases. There are various other examples of that. There's a mens rea case involving felon in possession laws, and there are various others, which shows that he assumes that criminal laws will be read narrowly and consistently with how they have been traditionally read, and he is hesitant about broader readings. And in this case, I think what was really doing the work was the arrest. That he said, under New Mexico law, this just wouldn't be treated as criminally punishable. And we shouldn't kind of bend over backwards to to defer to the police officer's judgment to engage in the arrest and conclude that there is probable cause for it, in the absence of real evidence that's a crime under New Mexico law. And he has certainly said the same with regard to federal law. In that respect, I think he might be similar to the justice he replaces, Justice Scalia, who generally took a relatively broad view of rule of lenity, which is how a lot of these issues play out, as to federal criminal law enforcement. So I don't think this tells us much about how he deals with gate-controlled speech cases, let's say, which involve government as administrator, where in fact, again, we know that conservatives generally have taken a relatively pro-administrator view. But I do think it's a reminder that in criminal cases, he is more likely to hold the government to its proof, to prove beyond reasonable doubt, and hold the government to the established readings of the law, even in matters of probable cause.
Moving to this area of public grievance, this is a case I'm sure you're familiar with, Van Dielen versus Johnson and Douglas County Board of Commissioners, 2007 case. Just briefly, the facts here: Van Dielen owned a home, his house was flooded, he sued the city or county board, I guess, because he said the culvert in the area was causing the flooding. The county responded by building a bridge, and then his assessments began increasing rapidly on his home, and he sued the county for the cost of the assessments. Among the claims he made was that he had a First Amendment claim to bring these grievances to the government. Government responded that he was not protected by the First Amendment, that he was doing this merely to advance his own financial standing, and Judge Gorsuch disagreed with that conclusion. You want to take it from there? Yeah.
Sure. So if you step back and look at the big First Amendment picture, we see there have been a lot of debates in recent years, recent decades, about when speech should be less protected on the grounds that it's supposedly a matters of purely private concern. Obviously, those in these rooms know this from the libel context. That's the Dun and Bradstreet case. Comes up with the government as employer, Connick v. Myers. It's possible that according to Snyder v. Phelps, suggests that when it comes to even true statements or statements of opinion, they might be actionable under the emotional distress tort if they're matters of purely private concern, even though they're not if it's matters of public concern. I've seen attempts to apply these rules in other cases, like, for example, something that Aaron Kaplan, who's sitting in this room, has written on, which is restraining orders against alleged criminal harassment, and also sometimes in criminal harassment prosecutions. The courts have been enjoining speech, not just unwanted speech to a person, the classic telephone harassment context or stalking context, but speech about a person. And occasionally, including I think in a few California cases, the rationale has been, oh, this is merely speech that matters of private concern, say insults of an ex or something like that, and we can issue an injunction ordering this person, even setting aside defamation law, ordering this person not to say things on matters of private concern about someone else. This is an important issue, and here Judge Gorsuch said when it comes to retaliation through the licensing process and the public, this extra latitude for the government to restrict speech on matters of private concern does not apply. That just because the government as employer can retaliate against its employees for speech on matters of purely private concern doesn't mean this extends to other retaliation claims. The government as employer context is different, and that both in the public concern test was meant to form a sphere of protected activity for public employees, not a constraining noose around the speech of private citizens. When you get outside the government as employer context and the areas where traditionally the government hasn't had any extra authority as manager to decide whom to hire and whom to fire, that test doesn't apply. Interestingly, in his concurrence in Mink v. Knox, which is a criminal libel case from Colorado, the majority held that the criminal libel statute was unconstitutional. He agreed, but he suggested that there's still an open question about when statements that may not even be libelous in the sense of knowingly false or recklessly false might be actionable as, say, infliction of emotional distress on matters of purely private concern. So it's an interesting question how open he'd be to this line in situations like, as I said, the one suggested by Snyder v. Phelps. But at least in this area, in the area of, again, government retaliation against people who are seeking various licenses and permits, he was willing to restrain the potential growth of the private concern test.
Okay. And in fact, at one point during one of these meetings, the sheriff's deputy threatened to shoot him if he filed an case.
Fair enough. Well, that raises issues even outside the prison.
Understood. Campaign contributions and political participation. Again, case Riddle versus Hickenlooper out of Colorado in 2014. I won't bore you with the specifics of the Colorado law, except to say that essentially what it provided is that their candidates could raise $200 for their state legislative race, but they could raise $200 in the primary and $200 in the general. And if you raised it in the primary, you could spend it in the general. So effectively, if you ran in both the primary and the general, you could raise $400. If you ran in only a general, you could only raise $200. And since there weren't primary campaigns for the write-in candidates, they were effectively limited to $200 in contributions where their rivals were able to get $400. The court, the court does not uphold this cycle, as I read this overlapping of them, and Judge Gorsuch concurs, talking about a very specific aspect. Do you want to take up that aspect of it, or should I summarize here?
No, you please.
In his concurrence, he says, no one before us disputes that the act of contributing to political campaigns implicates a basic constitutional freedom, one lying at the foundation of a free society and enjoying a significant relationship to the right to speak and associate, both expressly protected First Amendment activities. The reason I cite that is it seems to take as implicit those very values, that we're not going to draw a distinction between money and speech, and I know that this has been discussed for many years now, but I guess my basic question is, when you look at the totality of the ruling and his concurrence, whether it gives us any hints over where he may be headed in this debate over the proper role of money in politics.
I think the answer is it doesn't give much. I think it's a mistake to focus too much on kind of cases like this. Again, first, on the one hand, his hands are tied. On the other hand, the case is really quite unusual, and quite unusual in the probably the degree of consensus. I think you could get a 9-0 vote on the court today for the view that whatever you might do, you can't handicap write-in candidates compared to other candidates. I will say that that the question isn't here, I think, whether money and speech are different. Obviously they are, but it's like, imagine that the government were to say, you can get an abortion, but you can't spend any money on it. You can't spend more than $100 on it. Or if people provide it, they have to provide it for free. I mean, I don't think we'd say that's unconstitutional. Assume for a moment the abortion right exists as precedence, as it does, because money is an abortion, right? We'd say that the law unduly burdens the right to get an abortion. I think that's what cases like Citizens United and Buckley rest on. The theory that bans on independent expenditures unduly burden the right to speak. Certainly there are many people around here who represent newspapers who exercise their free press rights. If newspapers were told you can editorialize for candidates, but you can't spend more than $1,000 doing it, between the imputed value of that space and the time you spend on it, people would say, oh, come on, this is clearly an unconstitutional burden on the free press, but not because money is the press, and because there's no difference between money and the press, but again, because the restriction on the use of money for free press rights is a burden on free press rights. So my guess is that he's going to follow along with that view, but that's, again, just because that's where kind of the modern conservative intellectual legal movement is. And we are pretty sure that he's sort of within the core of that movement. Whether that will put him with Thomas, who takes a very broadly protected view, to the point where disclosures, for example, even are unconstitutional. Whether it puts him where Scalia and Kennedy have often been, which is taking the view that campaign contributions are fully constitutionally protected and not just independent expenditures. or whether that puts him more where, say, Rehnquist historically had been, where basically independent expenditures are quite broadly protected, but some degree of campaign contribution might be restricted. That's a hard call. It's very hard for us to tell.
Given the widespread, if not always terribly well thought out, response to Citizens United, put a certain kind of pressure on the court to address that issue again as.
I think it's easy for the court to punt on an issue regardless of public sentiment.
Sure, yeah.
But it's harder to punt when there are cases coming up where there are real splits. So I think that's going to be the issue. If, for example, the public sentiment really manifests itself in attempts to kind of revisit the Citizens United and ban or limit in various ways, say, corporate spending on related to elections, then they may have to return to it. Obviously, they did in Montana, where Montana basically tried to flout Citizens United altogether, and they smacked it down. But perhaps somebody else will try it again to see where Gorsuch stands. The other way, of course, that this could happen is there could be just a variety of challenges to other laws that over time might either reinforce or underline the underlying structure. But my sense is it's going to be a very slow process. It would be a much quicker process, I think, with a Justice Garland, because then somebody would say, okay, fine, time to totally ban corporate and union, probably, independent expenditures, and see which way the court jumps. I doubt that they'll be as eager to do this if Judge Gorsuch becomes Justice Gorsuch.
Can I just interject here? Could you guys just speak up a little bit? We're hearing that they're having trouble hearing you.
Uh-oh.
And DC, if you guys could mute your mics, that would help, because we're hearing a lot of noise from your end as well.
Okay, loud.
That better?
Very loud.
Okay. We have just a few more that I'd love to touch and then open it up to all of you. Defamation.
Yes.
The case that seems to most speak to his views on defamation is this Bustos versus A&E Television Network,
Right.
2011. Again, I'll give you a very short summary of the facts. Gorsuch wrote the opinion in this case. Bustos was an inmate at a Supermax facility in Florence, Colorado. While an inmate, he was approached from behind, talking to some other inmates, and the inmate approached from behind and hit him. As the opinion says, after a few minutes, baton-toting guard stepped in, but by then Mr. Bustos had caught a few good punches and was no better for the wear. Going on, the opinion notes that unfortunately for Mr. Bustos, this was all caught on a surveillance camera, and even more unfortunately for him, the A&E Television Network got hold of the footage and featured it in a national broadcast about the entitled Gangland Aryan Brotherhood. These particular images aired during the show in a sequence where there was, as the opinion says, a stentorian narrator who was describing the Aryan Brotherhood prison gang, its white supremacist views, and its violent history as we're watching Mr. Bustos get hit. His suit rested on several notions, but one of them mainly that he was not, in fact, a member of the Aryan Nation, that he was affiliated with the Aryan Nation, and I must admit I don't completely understand the difference. But in any case,
He didn't pay his dues.
He gets the newsletter, but he
Right.
doesn't.
Late news payment is really bad at the Brotherhood. So he's teasing out this question of what it means to be materially, whether it's a material statement that he's a member, whether that affects his public reputation. Take us from there.
Well, I think if you read the opinion, it comes across as, again, not a grudging application of libel protections of such a substantial proof doctrine or the background First Amendment principles which he acknowledges are in play there. But kind of a happy implementation. So there's no reason to think that he is like, say, his old boss, Justice White, for whom he worked with Justice White, was retired, who took a famously very broad view of libel, permissible scope of libel law, and a narrow view of First Amendment protections. And perhaps he might be more like Justice Kennedy, to whose chambers he was seconded for the time that he wasn't working for Justice White, who generally takes broadly free speech protective view, including seemingly in libel cases, although of course there haven't been a lot of libel cases recently. So my guess is that he is going to be open to relatively broad free speech protections against libel law. But again, how broad? Hard to tell for sure. There are a few privacy cases in which he has shown himself as kind of open to broad free speech protections, both external to the tort and within the tort, against disclosure of private facts and similar torts. Again, we don't really know. We don't really know how this would play out in other major cases.
He does seem, at least by just the language of that and a little bit of language we know out of Trump, to be not coming to libel and defamation from the same place that Trump is.
That's a very fair point. And that I do think there's no evidence at all that he is somebody who would open up
roll back or open up.
I believe is the phrase. Right. He seems to be sort of within the libel law mainstream, which today is generally quite protected. So, and again, looking at the tone of this, you can't know for sure, but I do think he's somebody who would take a generally speech protective view in libel cases. But again, how that would play out as to particular details.
Okay. Well, good. Now that I'm almost at the end here. One last area I want to talk to you about before turning it over to everyone would be parody. You referenced Means versus Knox earlier, 2010. Briefly, a college student lampooning a professor by the name of Junius Peak, cleverly calling him Junius Puke on his website. The court sort of dryly went through the evidence that this was lampoon or sarcasm, quoting at one point saying, the purpose of the site is to, quote, be a regular bitch sheet that will speak truth to power, obscenities to clergy, and advice to all the stoners sitting around watching Scooby-Doo. The question here was for Peake, who did not regard himself as a public figure, whether he enjoyed the protection of this parody as a private figure. And I'll hand it to you with that.
So the court did say that the criminal libel statute was unconstitutional as applied to parodies, because there is previous and circuit precedent saying that basically this kind of speech cannot be seen as actionable. Parodic speech cannot be actionable. And Gorsuch had a separate concurrence which basically said we don't need to deal with the question whether that's sound or not. It's the law, that's what we're going to stick with. But he did seem to suggest some openness to the possibility that certain kinds of parody, think sort of a hustler you follow, but as a private figure, private concern, that might be at least actionable as under the emotional distress tort. Actually, there's still some statutes that have a criminal libel statute. There's still some states that have criminal libel statutes that don't have truth as an absolute defense. That are required a showing of damage to reputation, and truth as a defense if it is good motives and justifiable ends. An opinion is likewise a defense warrant for legal fair comment, which requires some public issue. So in theory, you could imagine even a criminal punishment for that, although practically it seems very likely that the statutes are unconstitutionally overbroad, as in fact Minnesota Court of Appeals, for example. So the statute. But in any event, it does suggest that he may be open to allowing some liability for private concern speech that is, well, it's clearly, because it's a parody, isn't seen as a false statement of fact, nonetheless is seen as deliberately distressing.
Yeah, the language here, yes, it says that reasonable minds can indeed differ about the soundness of a rule that precludes private persons from recovering for reputational or emotional damage caused by parody about issues of private concern. Right. Seems open. Seems openly open.
Exactly. But what the ultimate result would be, very hard to tell.
All right. Well, this is the point where I was intending to pivot to all of you. It's hard to know how I call on people on a different screen, but who has a question no matter where you're based? Here? All right. How about we'll start with you?
All right. So for those of us who practice in the First Amendment area and are concerned about cases getting to the Supreme Court in the First Amendment area, the foremost question in our minds is this trade that we're about to get, Scalia for Gorsuch, a good deal for us or a bad deal for us. Do you have a general sense of how he compares to the
So-
cases you're replacing?
As to basically communicative torts, my suspicion is that he would be a little bit better, because Scalia had made some noise about taking a narrower view of libel law. We don't have any reason to think the same about Gorsuch. Again, there have been so few libel law cases before the court in the last few decades, few merits cases, that it's hard to tell for sure which way Justice Scalia would have gone. But I see no reason to think that this will make the court any worse for communicative torts cases. And as to privacy torts, it's not like Scalia was a privacy maximalist. He's Florida Supreme BJF, but at the same time, again, we don't know enough about him on that score. One interesting question is how it would play out, how all this would play out in the right of publicity, because this is an area which is supposedly ripe for revisiting. There are basically 5 different tests that have been applied by lower courts, and including last time with my colleague Jennifer, Aaron's colleague Jennifer Rothman, my former student, somebody I'm always happy to work with, and I wrote an amicus brief. Wrote amicus briefs in a couple of right of publicity cases, pointing to their pairs, 3 pairs of cases which basically I think are almost indistinguishable in the fact that along any relevant dimension, but the courts have come out in opposite directions on. So again, we don't know for sure which way Justice Scalia would have gone there, but there was the conventional wisdom. Justice Scalia was always hesitant to grant that he was just kind of very light hand on or be heavy hand to get. So one interesting question as to what extent would Gorsuch be open to getting some of these cases, whether because he feels, there are, 80 cases a year, they can handle a few more, and to what extent is he just somebody who is perhaps more interested in dealing with kind of juicy First Amendment cases. You could tell that he likes these cases. He just likes writing about them just from the road with which the opinions are written. But that's again another answer. I have no reason to think that he'd be worse on communicative tort questions. I suspect he'll probably be a little bit better. And he's probably, among the possible Trump nominees, he's the one who I think has the best record in favor of them. At least among the talked about.
Can I ask a related question to that, which is, what sorts of cases do you think that Justice Scalia was really the fulcrum kind of vote, where replacing Judge Gorsuch for Justice Scalia could really make a difference in the outcome? Are there any cases, other than campaign finance maybe, which seems to always be 5-4, are there any First Amendment areas that you think really could switch with this?
Well, I don't think they would switch, because I don't think this Gorsuch is likely to be that far from Scalia. So obviously the violent video game case Scalia wrote the opinion was a very important vote. So if we're thinking about 5-4 cases, maybe in which Scalia was in the speech-restricted majority, well, the area that there's always a question about is government employee speech. It used to be historically that conservatives will always be counted on to vote for, well, not always, generally be counted on to vote for extra government power, and the theory that you take the government, the king's shilling, you take the government paycheck, along with it comes some strings that if you don't go along with, you can be fired. One interesting question is to what extent will the move among conservatives towards a broader free speech views more generally, which I think we very much see from the president, to what extent would that end up playing out also in government employee speech cases like our city in Scalias and so forth? The answer was we haven't seen it yet, and I have no particular reason to think that Gorsuch would go in that direction, but it's conceivable. You see something similar with regard to case and control speech. Obviously, in Morse v. Frederick, or is it Frederick v. Morse? I always forget which way, which was Morse v. Frederick. Morse v. Frederick. So in any event, excuse me, pardon my throat. There, Alito and Kennedy were willing to have a separate concurrence suggesting, well, we are willing to see some protection for K-12 speech. And it's possible, again, that maybe Gorsuch would go even further there, or at least go where they are. So that would be an area that would be interesting to see, perhaps of less importance to people around this table with their practices, or at these tables with their practices, but that might be such an area. But it might not. It may be that Gorsuch will take, again, the traditional conservative view on this, which is less speech.
Hi.
Hi.
Laura Handman in Washington, D.C. You mentioned that Judge Gorsuch clerked for Justice White, and of course Justice White was the author of the majority opinion in Brandsburg v. Hayes, which purportedly found no First Amendment reporter's privilege, but left open the door that there could be a common law federal privilege, which at least Judge Tatel here in D.C. has espoused as something that the federal court should recognize. Given the already launched, allegedly leak investigations, do you see how Judge Gorsuch might come out on whether there should be some recognition of a federal reporter's privilege?
I wouldn't focus much at all on Gorsuch having been hired by White, simply because, to my knowledge, White was never somebody who focused particularly much on ideology. Ideological compatibility with his folks. I mean, my sense is Justice White did the same view as Chief Justice Rehnquist did, which is, I don't care what their ideology is, they're going to write things the way I want. And certainly, for example, my year, Chief Justice Rehnquist had 3 clerks. All of them are basically moderately liberal, I'd say. Some justices, of course, did hire only clerks who are relatively compatible with them. Generally speaking, Justice Blackmun, for example, in his later years only would hire liberals. Justice Thomas generally would hire conservatives. But by Justice Souter, at least in my year, all of his clerks were liberal. But I wouldn't focus much on White. The Brandsburg v. Hayes question is, of course, a very interesting one. But again, there I would focus more on kind of where the modern conservative and liberal movements are. And my sense is conservative judges aren't sold on the proposition that there ought to be what they see as a special exemption for either the media as an industry, that is to say professional media, or from news gatherers writ large, from the basic duty to tell. So I wouldn't expect much from Judge Gorsuch on this, either as a constitutional matter or as a common law matter. But it's almost possible. It's almost possible. The interesting thing, of course, is the court has just refused to focus on the issue ever since Brandsburg. And my sense is they've had plenty of opportunities, including once there was a pretty solid split among the circuits. So maybe just one question is going to be, the first thing is to get the court to hear the cases. And one question is whether Gorsuch would be inclined to vote the grant just because he feels the need to clean things up. By the way, that was another thing that Justice White was famous for. That he was always was usually a pretty solid bet for a grant whenever he saw a split. He sort of saw that as the duty of the court. And I don't know where Gorsuch would stand. So that would be probably more my calculus, how likely it is that it is just going to be a traditional liberal conservative. There's, of course, an extra monkey wrench that's been thrown into all this in recent years, maybe even recent decades. One of the rationales that the majority gave in Brandsburg was that you can't distinguish the professional media from non-professional media, and therefore, if you grant an exemption, if you essentially allow a privilege, that will be applicable not just to journalists, but whoever happens to call himself a journalist or a reporter. Obviously, this is even more clear today because where do you classify somebody who's running a blog? One possible answer is it's not a problem because if anybody who runs a blog does want to claim a privilege, not much is going to be lost by allowing it. But on the other hand, there is more of a concern that kind of ordinary conversations, you say, let's say there's an employer who's being sued for job discrimination, whatever else, somebody there and said, well, I'm a blogger on my spare time. And the conversations we had about it simply, we were talking about a possible blog post that might have come up. One of the problems is because bloggers don't have beats, don't have specific projects that they're accountable to someone for, pretty much anything could be said to be gathered for perhaps eventual news reporting purposes. So those are the kinds of issues that I think the court today would have to deal with, and it's hard to say where Gorsuch would land, except again, it seems there is something of a conservative liberal divide, and that divide is not in the media's favor.
I was just going to ask you, what's up with the television commercials? Did have you ever seen them before?
I never.
Did anybody approach you?
I don't know. Didn't know there were television commercials. I don't watch any television.
There's a television commercial where a fellow clerk advocates for confirmation and then assures the viewer that she was part of the Obama administration.
Oh, this is a former Gorsuch.
Well, no, I'm not sure.
I think this was. I haven't heard something about
Gorsuch.
I don't think so because
Okay.
I want to know her. I mean, I now have this vague memory of an email about this commercial, and I think it was about a former clerk of his. And I will say,
I think my memory is
I think she was clerk of his, and then went on to the Supreme Court.
Right, she clerked for Justice O'Connor, I thought she said in the commercial. Anyway.
And she went on to work for the Obama administration.
Right.
Right. That was her liberal credential in the commercial.
Mm-hmm. Right.
Well, it may be that her liberal credentials are indeed impeccable. It may very well be, because he may very well have liberal law clerks. My sense is that he has liberal as well as conservative law clerks. This doesn't mean that all this, of course, law clerks love their judge, and my sense is Gorsuch is a lovable fellow. And in fact, not just my sense. I know him I've kept in touch with him since clerking, and I've always been struck by just how friendly and gracious he is. I'm sure he is a wonderful man to clerk for, and I'm sure that his clerks feel quite loyal to him. So I suspect she's entirely sincere, but I think it's not uncommon.
I was doubting. I was asking if you've ever seen a promotional campaign for confirmation.
Well, someone mentioned that may have been sort of Bertha Kagan, but I wasn't watching television commercials with him back then.
I read this morning that Kagan said there were ads against Kagan by NRA and also ads for Kagan, and the people who placed the Trump one, Gorsuch, sorry, it's called Judicial Crisis Network.
Right.
Because there's a crisis.
Well, the fact is, when the court has as much power as our court does, and when the appointment of the justices is a political matter, it's not surprising that people would try to reach out to the public as well as the senators directly. That's, in a sense, that's democracy in action. And it's also unsurprising, notwithstanding that my sense is more print media heavy in terms of the client base or in the term, but my sense is it's unsurprising that if they want to reach out to the public, they do it through television rather than through, letters to the editor, right? So it may be unusual in the sense that it hadn't been done much before, but, that's life in a democracy. This is the one, the Supreme Court is a counter-majoritarian institution, but it is literally not an entirely democratically influenced institution. The time when there is some democratic check is at the time of appointment, and it's unsurprising that the demos is being urged into action, especially since there's some indication that many Trump voters were actually voted for him because they were at least they said they were concerned about this.
What did you think of the hold on Garland?
Well, I think it's politics, but I think that it's politics in a political process. And I think that if you hadn't had, I'm getting the confused, I think it was Biden back in 1992 essentially threatening something similar, which didn't happen to him.
Right, yeah.
But he threatened it, and then the president who nominated Garland voted, I believe, against both Roberts and Alito and filibustered Alito. And filibustered Alito, my sense is for no reason other than that he didn't approve of Alito's ideology, he probably wouldn't have approved of the ideology of pretty much anybody else that Bush would have nominated. It's unsurprising that the Republicans would say, well, all right, this is what we're going to do. Now, I should say, I'm not faulting Biden for what he said back then. I'm not faulting Obama when he was senator for having filibustered or having voted to filibuster Alito. That too is politics. But again, the process of the president selecting and then the Senate approving or disapproving or putting on hold, which is filibuster is essentially putting on hold, a nominee for the Supreme Court, that is a political process. And it's hard to say, oh, this is ugly politics. It's maybe hardball politics, but it's not the first step. I mean, it's the same thing as with regard to the filibuster. Will the Republicans vote to drop the filibuster on Supreme Court nominees? Well, probably I think it need be, and in part because the Democrats voted the same way with regard to Court of Appeals nominees. Is it identical? It's not identical. But the fact is that if one party is willing to do this closely related area, it becomes very hard for the other party to say, no, we care about the traditions of the Senate, or even we care about the future. Because again, one aspect of politics is that people care more about the now than about the future. Unsurprising, we see that in economics too. We discount the future to profit a pretty steep discount rate. So, this is a political process. I don't think that all judging by any means is a political process, but I do think that the process we're going through now is a political process.
Hi. Yeah, can you hear me? This is Dean Rangel in New York. I want to ask something which relates to the First Amendment, but extends a little bit more broadly. Whether or not we have any information on it, not clear to me. And it was raised, I think, a little bit by the Ninth Circuit argument on the stay a couple of weeks ago, going back to Pentagon Papers. Do you have a sense of what the judge's view of the role of the judiciary, if any, in dealing with national security issues? Is there any data, anything that tells us about that?
I don't think so. And I think that's also a very hard thing to predict, partly because lower court judges so rarely deal with it, and partly because the responsibility is so much greater when one is up on the Supreme Court, and partly because national security issues vary much more over time. I do think that Gorsuch has shown himself among the judges who is most willing to push back against executive authority. We see that in some of the criminal justice cases with reading criminal laws in a relatively narrow way, working in mens rea presumptions and various other things, essentially saying no to prosecutors. We see it in the Yellow Bear case with regard to religious liberty and British Land Use and Institutionalized Persons Act. Our Lupa claim on behalf of that case was an American Indian inmate who wanted to use a sweat lodge. We see that with regard to pushback against prison wardens, claims of executive authority. And we see that in skepticism as to the Chevron doctrine and more generally the power of administrative agencies, also pushback against executive authority. So it's possible that he's actually more willing to push back against executive authorities than Judge Garland would have been, from what relatively little I know of Judge Garland's track record. When it comes to national security issues, though, it's very, very hard for the reason that it's going to be a different kind of case that he dealt with before at a different position than he's been in before, so who knows?
And maybe for both of you, given allegations of fake news and attacks on various channels or whatever of news, do you see any litigation arising out of that? What might either the nominee or the court do if it ever got that far? Is it an attack on the press?
I'm sorry, what's going on with the weird I think the microphone.
These are the handheld microphones.
Handheld microphone should be turned off,
Yeah.
muted.
I don't know how to answer it in terms of litigation. I mean, I think there's enormous burdens on serious media now to calibrate correctly with respect to him. And I think evidence that mainstream news organizations, big ones, New York Times and Washington Post in particular, and the Wall Street Journal, are doing a fairly good job of it, and notwithstanding the lampooning that they're getting. I can't imagine that there would be much appetite in any of those newsrooms to bring a lawsuit against him. And it just feels like a level of conflict that no one would be comfortable with. But I do think that, I think that news practices, press conference practices are going to change. I suspect there's going to have to be some understandings among reporters about who gets bypassed for a question and how you cover for that person. So I think it will change some media habits. I don't know if it'll be litigious.
Well, so I thought that you were asking whether there'd be lawsuits against the purveyors or distributors of things.
Oh, sorry.
Is that what you're asking?
No, just in general, that there is fake news and there's allegations of what is or what isn't fake news. There seems to sort of be, for me, the attack on the press. That's a good part of that issue.
Well, so
it's a whole big, whole new world.
I'm generally a believer in that most likely what the legal system will do is it'll just barrel along the way it's done before. Sometimes that's a bad prediction, but most of the time that's right. Somebody once said, law is the only discipline in which the phrase "that's an original idea" is a pejorative. If someone is thinking about suing over fake news, well, the key question, of course, is it fake news about a particular person? And if it is, well, we've got a label for it. It's not fake news, it's libel, right? Or maybe false light invasion of privacy, you might have a lawsuit. And if it's the claim is fake news that isn't about a particular person, at least is negative towards a particular person, then it's quite unlikely, unless you have an unusual false light situation, it's quite unlikely you're going to have a viable claim. And that's basic advice I'm sure we give anybody who'd ask this. We'll stick with it. Likewise, if somebody wants to sue President Trump or somebody else for calling them fake news purveyors, right? Question is that libel? And my guess is that in this climate, it's kind of like suing over calling someone a racist or someone calling someone a fascist. That would be understood. There's actually case law labeled as racism, but in the absence of some very specific interpretation of this, that's just a pejorative. That's just a generic pejorative that people use because it covers everything from outright lies to honest mistakes to merely a claim that somebody isn't really presenting things in the proper perspective or something along those lines. But again, if somebody were to say, this particular reporter, obviously you could libel the New York Times. The New York Times is unlikely to sue. But a particular reporter might. This particular reporter is distributing fake news because he knows that what he was saying is false. Well, that's an allegation of somebody lying, especially in a profession where lying is viewed quite negatively. In principle, you can imagine there being a libel lawsuit. But of course, there also are the usual constraints to bringing libel lawsuits. As I take it, many lawyers here on the defense side, we cherish them, right? A lot of people won't bring a libel lawsuit because that just amplifies in many respects. Even a perfectly legitimate libel claim amplifies in many respects the initial defamation. So I doubt there's going to be much litigation. I think it's going to be sharply constrained by these constraints. But as having been said, you could certainly imagine an exam fact pattern where I get to line up something where one of the issues that the student has to spot is, well, yes, there might be a libel. New York.
We're veering off your view of Judge Gorsuch, but just to follow up on fake news, there is that, I agree with you about libel being a remote area of liability in fake news, but there are those rare cases where the cookbook and use the pressure cooker and it explodes in your face, or the old RKO case where an advertiser offers $500 if you can spot the station's car driving through the city, and people get injured in relying on fake news. Not a defamation claim, where First Amendment has not eliminated all of those kinds of claims, which are at least theoretically possible in today's world of fake news?
Well, so that's interesting. Although interestingly, that's usually something that's not covered under the label of fake news. So the case that this puts me in mind of is Winter, I want to say G.P. Putnam and Sons, the mushroom encyclopedia case. And my mother, I was born in what's now the Ukraine, but basically Russia. My mother would go and look for mushrooms. It was considered kind of very, very fun thing to do, especially since, unlike in America, where you go to the supermarket to look for mushrooms. The only way you found them is in the forest. And boy, you were careful in making sure that you pick the right mushrooms. So my assumption was that if there's anything you should be able to trust as a product subject to product liability law, it would be a mushroom encyclopedia. But of course, the Ninth Circuit held no, in part because of First Amendment concerns, at least wouldn't be strict liability, maybe not even negligence liability, basically not even negligence liability for the publisher, for outright errors in mushroom encyclopedia. We don't think of it as a fake news case because it's not fake in the sense of a lie. It's not even really news, but that's an area where, let's call it negligent falsehood, or falsehood that negligently inflict harm, were found not to be actionable. And then occasionally you see situations where there might be actionable. The classic example in the same area is aviation charts, where if they displace the elevation of a mountain, well, then in that case, that is actionable. So these interesting things. Interesting in the RKO case, which is an interesting California case, which involves liability for a radio station for running a contest where really it was almost certain that people would have to speed and otherwise drive unsafely in order to win, was liable. But that's not a fakeness issue at all. So there are these interesting questions of the borders of First Amendment law. I think they would rarely arise at rights level or the rights level, would rarely be presented as a fake news issue. Now, one thing as to the violence, the injury, where it came up in the fake news context, was I think a pizza store story, where I think somebody heard these theories that the pizza store was a front for some child pornography or child molestation, child sex trafficking operation, and showed up there with a gun. I think that would be a more natural home. For that would be liable. Well, obviously, the possible harm there isn't just injury to reputation, but physical injury caused by the injury, by retaliation that's caused by the injury to reputation. But again, I would try to fit that more into the libel context and come up with some specialized fake news theory. You see? You see? Can't hear you. Can you hear us? We can't hear you. Who can't hear you?
We put the mic on mute.
Gotta unmute the mic.
Nope, can't hear you still.
Let's try that.
Get back.
Go ahead, Bob.
Okay. Can you hear me now? Hello? No?
Yeah.
Okay. Picking up on the point you made earlier about Judge Gorsuch and his skepticism about executive power, it seems one thing that distinguishes him from both Justice Scalia and Judge Garland is his willingness to reconsider the Chevron doctrine. What implications does that have for regulation of speech by federal agencies like the Federal Communications Commission?
That's a great question. I know nothing about the subject, and despite that, I have no opinion. This is, this weird professional division. Now, that's a matter of communications law. What I do communications law? Well, no. So there's this whole zone of federal communications law that's tremendously important, but I'm just not knowledgeable enough to know what's likely to go on there. Obviously, the First Amendment constraints of federal communications law are already largely immune from Chevron in a way. But what do you think? I mean, this maybe well, either you practice it the same amount as I have, which is not at all, or more likely you practice it more than I have.
What I can tell you is that Justice Scalia was willing to defer to the FCC on its change of interpretation in its indecency standard to be less speech protective. I guess my question is whether or not, if Judge Gorsuch were on the court for a similar case, whether or not the less First Amendment friendly approach would get the same level of deference.
Yeah, so the interesting question with indecency is, if you set aside deference to the FCC, is the statutory version any better? And maybe he might conclude, maybe he might be more likely to conclude it's unconstitutionally vague, because he doesn't think the vagueness can be well cured by agencies. Alternatively, one other way of thinking about it, you may say there's a delegation problem here.
It is a delegation.
The Congress can't delegate all this authority to agencies, and in particular, if it enacts a vague law, it can't delegate the business of cleaning up after that to a federal agency.
Yeah, Congress can't delegate constitutional power it doesn't have.
Right, and in the area of vagueness, and maybe that might end up where some of the justices weren't specific, which is the only way of rescuing that is a not very textually satisfying one of reading indecency as more or less obscenity. But it's hard to tell, and that's one of the things that we know about Chevron deference and evaluating Chevron deference, that influences very heavily the power of the executive versus vis-a-vis the other branches, especially not just the legislature or the judiciary, but it doesn't necessarily give a broad tilt to the outcome in any substantive area, because there may be some areas in which the agency's decision to be more substantively to one's liking, and another in which maybe less.
Yeah.
I mean, the interesting thing, of course, is we have on the court two justices who've already said they're willing to reconsider Pacifica, and they are Ginsburg and Thomas.
Yeah.
And my assumption is that if there's actually a list of grads, they're not just outliers, but they are the vocal minority of a broader group that somehow centered around them that could end up adding to that. And it may be also that Gorsuch might be more likely to be on that side just because of age. I do think that attitudes have shifted some with regard to these kinds of things over the decades, over the generations. But where he would come out, or where the other justices would come out on that question, is hard to tell. And again, I think it's more an issue of whether a vehicle will come up and there'll be 4 votes to grant. That's sort of the bigger issue.
I think we've got time for one more. And Bob, if you could mute that mic now so that yeah. Thank you.
As you were reviewing the case law, there were a number of opinions where Judge Gorsuch wrote a separate concurrence, which you don't see all that often in the courts of appeals. So I'm wondering what you make of that. A, is he more likely to do it in speech cases than non, and do we care about that? And then in general, what do you think that portends?
So my sense of Gorsuch is he's an intellectual. And I'm not saying necessarily as praise. I have 2 boys. One's an intellectual and one's not. And there are lots of people who are tremendously intelligent but not intellectual. And there are some who are intellectual but not about a particular area of the law. He loves ideas, I think, and he loves ideas about law. And one evidence of that is he got a DPhil from a doctorate from I think it's Oxford. And I think based on his dissertation, he published a book on euthanasia and assisted suicide while he was a lawyer in practice at Calif, I think. And I noticed because I looked, I read it, I thought it was very good. I will say I couldn't have predicted kind of the casualness or the engagingness of his writing style as a judge from that book. I think it's a well-written book, but it's very much within traditional academic writing style. But I do think one thing one could have predicted is this is somebody who loves law, loves legal philosophy, loves legal ideas. And those are the sorts of people who are likely to say, I have this slight difference of opinion, and not enough for me to dissent, let's say, but I do want to note it because it's an interesting and important point. Or, as you can see in some of his other opinions, we could just, and Justice White was, of course, very famous for this, just dispose of this in a few paragraphs because that's the doctrine and that's fact. Or we could spend some time talking about the policy issues and discussing more broadly, not because it's rhetorically terribly important, but because it's interesting and it's useful to readers and it's fun for the author to write about it. So I think that's what we're seeing. I think we're seeing a judge who loves law, who's interested in writing about law, who wants people to understand not just here's the bottom line result, but why did we reach it and what's the broader context. And yeah, I suspect you're going to see more interesting opinions from him than from many judges, and more separate opinions.
All right. Well, on that note, join me in thanking Jim and Eugene. And we will hopefully see you in early April, my video cast from New Haven. Thank you.